Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to another episode of Legal Ease, the show that converts legal jargon into legal ease. And tonight my very special guest is Junaid Noor-Mohamed from Noor-Mohamed Attorneys in Greenside, Johannesburg. Now you might recall that Junaid has been a guest previously on the show where we dealt with unlawful arrest and police detention, including the means of securing evidence of torture used by the police. But tonight we're covering a very different subject, but also in the field of criminal law. And tonight we'll be talking about sentencing in the Criminal Procedures Act. Junaid, assalamu alaikum and welcome.
Wa alaikum assalam, Ashraf. Thank you for having me on your show, and good evening, assalamu alaikum to you.
Thanks for making yourself available. Now, Junaid, of late, there's been a number of high-profile cases in the press, and there's been a lot of reporting of a particular case, and I think the case has now concluded today in respect of the submissions by both legal teams in respect of sentencing, and the judge will probably hear closing arguments tomorrow and then make a finding.
That is correct, yes.
Now, what, in respect of just generally, what is the difference between a civil and criminal case? It's just so that we get a perspective on the subject.
Well, Ashraf, if you look at a civil matter and if you look at a criminal matter, you have the civil procedure and you've got your criminal procedure. And the parties are identified differently. In a civil action, you've got the plaintiff and you've got the defendant. The plaintiff could be a company or an individual or someone else for that matter, and the defendant could be anybody for that matter. In a criminal matter, we have the state, who is dominus litis, and you have the accused, who are the two parties. The state is represented by the National Prosecuting Authority, whereby prosecutors or state advocates are then allocated.
Now, this is across all courts, correct?
That is correct. Across all courts, district courts, regional courts, high courts, and even appeal courts as well.
Now, in terms of the Constitution, the accused in a criminal case, he's got certain rights guaranteed in terms of Section 35(3) of the Constitution. What would those rights entail?
That's correct. The Constitution, with the advent of the Constitution, which is the supreme law of the country, came with many changes to the law. And it's very interesting to note how law has developed over time and continues to develop over time and with time. And while the Constitution came into being, the Bill of Rights, which encompassed the right to human dignity, the right to life, the right to a fair trial, the right to be informed why you are being detained, for what you are being detained, and to have the right to a legal representative if you cannot afford a legal representative. The Legal Aid Board, which is a government body that is funded to give those individuals who are unable to afford legal services of private attorneys to then go with the Legal Aid Board attorneys which are present every day at court and then represented by a legal representative.
But I think the underpinning principle is the right to a fair trial. That's
Yes.
what the Constitution guarantees.
Correct. Right to a fair trial encompasses many things, Ashraf.
Yes.
It also holds not only the prosecutor and the defense attorney, but also the magistrate and judges to accountability in the manner in which a trial is conducted, especially a criminal trial.
Now, the defense in a criminal trial would have the right to all of the evidence that the state holds, even before the hearing. Is that right?
That is correct. Before, in the past, the defense would not have the right to have, or would not see certain documents. And this affected the preparation of the defense attorney or the or for the accused, in fact, representing the accused. So with now having the right to a fair trial, the prosecutor, or the state rather, is obliged and to furnish the defense with all facts and all documents that they have in their possession to be given to the defense attorneys or the defense team, even documents that are advantageous to the accused.
So really there is no lack of preparation for any defense counsel, because the state is obliged to give all of the documents and whatever they have, whatever evidence they have. So you can't catch the opposition by surprise, basically. You're obliged to give all the documents, and the defense is to prepare adequately, correct?
That is correct.
Right.
And just a few months ago, when I was sitting with a state advocate, and we were ordered to have a meeting, and we were supposed to compare files. And the state advocate then said to me that the documents that is being furnished to me for preparation is what he thinks is relevant. And I took umbrage to that statement, and I said, but hold on a sec here. If you have prepared these documents to what you think is relevant, clearly that is not correct. The main reason is what may be relevant to him or irrelevant to him may be relevant to the defense team itself. And then from upon that, I requested to be furnished with all documents. In S versus Van Rensburg 1963 decision, that principle of where the state needs to give you every single fact, even if it's to the accused benefit. So if my 8 lever arch files, Ashraf, then went to approximately 17.
So that shows you the amount of preparation that defense attorneys have to really go through in order to give their client the full value of their services. But Junaid, what is the process within a criminal court? How is evidence led? Who begins, etc.? Can you unpack that?
Sure. In a criminal matter, the state is dominus litis. Dominus litis means the party that is responsible for holding, or rather running, the trial. The duty to begin in a criminal trial rests with the state, and the onus to prove beyond a reasonable doubt that the accused did in fact commit a crime that he is being charged with, whether it be culpable homicide, whether it be theft, whether it be murder, sedition, treason, possession of unlicensed firearms, etc. And the state has that duty, or the onus rather, to prove beyond a reasonable doubt that the accused did commit the offense. And that's what culminates thereafter, where the state then, you have a pre-trial conference, both parties sit together, the state, the prosecutor or state advocate with the defense team, and you discuss how many witnesses you will be calling, how many expert witnesses you will be calling, and the defense too will notify the state of their witnesses that they will be calling, what would they be saying, and etc. Similar format to civil procedure, but in a nutshell, then you basically then proceed to trial.
Right. But the onus, you spoke about the word onus. What that really means that the duty is on the state to set out its case. For example, if we're speaking of murder, it is the state's duty to prove the elements of the crime of murder, which is the intentional, unlawful killing of another human being.
That is correct.
So if there's one element missing there, then the state has not been able to prove its charge beyond a reasonable doubt.
Correct.
Right. Now, The case that has made the headlines recently basically started on the premise that the accused was charged with the crime of murder.
Yes.
But the judge found at the end of the day that the accused was guilty of culpable homicide.
Yes.
And that's where we're going to talk about sentencing. Now, traditionally, sentencing was not as we know it today. It was an extremely confined way of dealing with a particular crime.
Yes.
There was a time that for murder, you got the death penalty.
Correct.
Now, that's no longer the case. So let's just talk about sentencing.
Okay. So you go to trial. Your evidence is led by the state by calling their witnesses and expert witnesses. They are not allowed, the state is not allowed to ask leading questions. They may not lead the witness to a question of asking where you get a yes or no answer. Once the state advocate has finalized his examination in chief with that witness, the defense team then has the opportunity to cross-examine the witness and point out irregularities, contradictions made by that witness on statements, etc. And
that's witness by witness. You take one witness, you lead that witness in examination in chief, the defense then cross-examines, and then if it's your witness, says you're the state prosecutor, you then lead, you re-examine the witness.
Yes.
Correct.
Yes. One of the things about re-examination is that if your case has been damaged through cross-examination,
yes,
and you find that your witness has now really contradicted himself or herself on various occasions, one of the rules of law is that if the damage is done, let it be. Do not try and pick up the pieces with re-examination, because then you are just making it worse for your case by pointing out the actual pieces that you are trying to now, put back together.
Right.
Talking about now, after going through witness to witness to witness, these are the facts once the state closes its case. And like you mentioned, that where the state is unable to prove an element of a particular crime, whether there was intention or no intention, etc.,
yeah.
Then you may apply for a Section 174 discharge in terms of the Criminal Procedure Act, which is Act 51 of 1977. This is where the defense team stands up and makes a formal...
Now, this is at the conclusion of the state's case, right?
That's correct.
So the state would lead all its witnesses. You'd have an opportunity to cross-examine. The state will re-examine. And then the state says they've closed their case. So
yes.
Before the defense leads, you bring an application in terms of 174.
Correct.
Okay, what is the effect? How is that brought about and what is the effect?
Just to go back a step, with your cross-examination by the defense team, you need to put the version of the witnesses that you will be calling and what they will be testifying or will be saying in the stand, and what the complainant's the accused version would be as well. You put it to each and every witness. You have to do that with each and every witness.
Or you could make a declaration up front, as in the Diwani case.
Yes.
Where Diwani gave a plea explanation.
Correct.
So his version was put out in the public domain before the actual trial started. So everyone knows what is his defense.
Yes, what the defense is.
Okay. Junaid, I'll ask you just to pause there and ask the viewer to just join us after this very short break. Please stay tuned.
Here at Pushir Motors, we make every effort to find you, our valued customer, the best possible used car to suit you and your every need. Our friendly sales staff will assist you from viewing and test driving your next premium selected sedan, SUV, bakkie or 4x4 vehicle. We also assist you in arranging finance with most of the popular financial institutions. For buying or selling, vehicle financing, and a view of our cars in our showroom. Come in today or visit us online.
You're all about style, quality, and setting the latest trends. You have the perfect home that's not only your comfort zone, but also a special space reflecting you. Express yourself at Essop's Home with our wide range of affordable quality designer furniture, from lounge and bedroom suites in the finest wood and leather, to chic frames and glittering chandeliers. Find your nearest Essop's Home from our 8 stores. Visit essops.co.za.
Fruit and aloe vera juice. No preservatives, no additives. Good till the last bits. Taste it, you'll love it. Another quality product from Marhaba Trading.
Advanced retail technology, specialist solutions and innovative sales concepts. One name is the new face of innovation, Marla's. With a world-class facility, state-of-the-art workshop, sophisticated technology, over 200 parking bays, kids' play area, gourmet restaurant and coffee shop, together with the best prices. Your one-stop multi-branded wheel and tire superstore. Embrace a world-class experience. Marla's, driven by you.
Take your first step in estate planning, wills or trusts with Legacy Fiduciary Services. You'll find our team of skilled professionals genuinely interested in your family's needs. Our professional team can advise you on wills, trusts and estate planning. Contact Shaukat Mukadam on 021 67 11438 or go to legacyfs.co.za. Legacy, your wealth for generations.
A better tomorrow starts with today. Are you committed to achieving professional and personal goals? We provide great opportunities to best fit your needs and career. power-online.co.za.
Assalamu alaikum and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight my very special guest is Junaid Noor-Mohamed from Noor-Mohamed Attorneys. And we're discussing sentencing in terms of a criminal trial. Now we've heard that at the conclusion of the state's case, there is a sentence to be pronounced by the judge. But as we've seen recently, there may be submissions made by the state as well as the defense. The state would argue for an aggravated sentence and give reasons for that, and the defense would try and get a mitigation in to reduce the sentence. Now, Junaid, what are the principles that underpin sentencing? What are there? Is there, for example, is there a minimum sentence for a crime?
Yes, there are minimum sentences today. Once the state closes its case, the defense team needs its witnesses, closes its case, and the judge or magistrate then finds the person guilty on whichever counts. There can be numerous counts, 294 counts or even 4 counts, one being murder, one being culpable homicide, one being reckless and negligent driving, etc. And there are competent verdicts as well.
Right.
So you may get away on murder, but then you'll still be charged with attempted murder, etc.
Right.
Now, in the past, there was no... one of the difficulties that magistrates and judges had was once they convict or find somebody guilty, they then have the onus, which lies on their shoulders, to pass an appropriate sentence.
Right. So it's a duty, basically.
Correct. And this duty needed to also be in line with the Constitution. The main reason for passing a sentence, the judge or magistrate needs to keep in mind that it must not be a court of injustice to the accused. And with the advent of the Criminal Law Amendment Act, Act 105 of 1997, it made things a little bit more easy for judges and magistrates, as the Act laid out minimum prescribed sentences for serious offences.
So basically what you're saying, it removed the discretionary element.
Correct.
Because there was a minimum prescribed sentence for a particular kind
Yes,
of.
yes.
Now, I
And-
think the underlying principle was always justice had to be tempered with mercy. That's
Yes.
what we often hear.
Yes, and obviously to not lose sight of passing a sentence to deter somebody from not doing that same crime again.
So sentence was also a method of deterring crime.
Correct.
Right.
Correct. But when you go into criminology and of behavioral psychology, and what always interested me, Ashraf, was what makes a criminal, what breeds a criminal, why does somebody do X and not Y? And this is where you can bring to the fore the background of somebody's upbringing, his lifestyle, or her lifestyle for that matter. You can use as mitigating factors, such as if he grew up in a in a neighborhood where it was continuous violence all around him or her, and
Now the defense would prepare for this.
Yes, correct.
So they would call experts. For example, in this case, they called a expert called Annette Vergier, and she's very well known to give reports that assist the court in assessing the particular individual that the court is now trying to sentence.
Yes.
And I think her report, for example, we're using hers, said that prison was the wrong place to send this particular accused.
Yes.
Right.
And due to the particular accused's
Personal circumstances.
personal
Yeah.
circumstances. And so you look at, number one, the youth of a person as a
Right.
mitigating factor. That would be used for the defense team. You'd also look at if this person has a family, has children as well.
Right.
You also got to look at the social upbringing and the environment, like I
Right.
just mentioned earlier. Was there alcohol abuse? Was there
Previous convictions.
drug abuse as
Right.
well? Was there remorse shown by the accused? By normally pleading guilty, you find that a judge or magistrate is more lenient because it shows remorse
Right.
from the onset.
But by the same token, the fact that you plead not guilty and you take full advantage of the rights to a fair trial
Yes.
doesn't mean that it can be an aggravating circumstance. They can't say, well, you've now aggravated the court.
Sure. Look, I mean, Ashraf, you know this, that each case and the circumstances of each case are different.
Right.
So the judge will have to then take that into consideration by reading up previous case law and what did a previous brother or sister of his, is that what we call the law, the judges call one another brothers, my learned brother, my learned sister,
Right.
said in this decision that you could deter from the prescribed minimum sentence being 15 years, even though you're a first offender, and you say, for instance, you found guilty for murder, and you're a first offender, you have no previous convictions.
Right.
It doesn't mean that you will not be imprisoned.
Right.
There are cases where people have been imprisoned.
Right.
But to deviate from the prescribed minimum sentence, there needs to be justification and substance to what is being mitigated. There needs to be shown that, yes, this person did grow up in a rough social environment and had
Right.
a very rough upbringing, if I might put it like that. Or he was suicidal and his mental capacity was affected due to being seeing his parents drink alcohol and seeing his mother injecting.
Just ask you to pause there and just
Yes.
remind our viewers that the telephone lines are open and you're welcome to call on 011 086 7700 1, 2 or 3, and the number appears on the screen. Junaid, please go ahead.
Yes, so those are your mitigating factors. You
Right.
can also use mental impairment, lack of capacity as well. Obviously, this all needs to be justified.
Right.
So like you say, you bring in an expert, a psychiatrist, for instance, who evaluated the accused and will then go onto the stand and testify under oath that these were his findings, that he does suffer from depression.
I think in this case an important trial within the trial was the question of heightened anxiety disorder of the accused.
Generalized.
Yes, and it went into a whole inquiry and psychiatric observations, etc. And a report was made that the judge took into account and found that that was not a relevant factor in this particular case.
Correct. Correct.
So what other principles underline sentencing?
Right. So once you are able to justify the mitigating factors that I mentioned earlier, you then are able to persuade the court to give you a lighter sentence. So instead of getting 15 years, you might get correctional supervision, or you might get 5 years suspended sentence.
Right, Junaid, I ask you just to pause there. Caller, we have a caller on the line. Please go ahead, caller. I think we've lost that caller. Sorry, Junaid.
Okay, so you would get a suspended sentence with an option to pay a fine.
Right.
And paying a fine is, in fact, punishment. A cautioning is also punishment. It constitutes a sentence.
Community service is sentence.
It's part of your punishment.
It's punishing, yes. It's a fitting sentence in certain cases.
Correct, correct. And correctional supervision is where somebody is under house arrest 24/7.
Right.
Alternatively, it could be that he needs to go and serve community service 16 hours per month or per week.
Just pause there, please, Junaid. We have another caller. Caller, please go ahead.
Assalamu alaikum.
Walaikum salam.
Walaikum salam.
How are you keeping? My name is Noor-Mohamed Boroko.
Yes, Zaid.
I want to ask you whether can you help me with this matter. I am looking actually for somebody who's specializing in contractual matters regarding aviation.
Aviation.
Yes.
Okay, Junaid, Zaid, I'd ask you to just leave your details with the producers. Alternatively, call us after the show. We can point you in the right direction, depending on the kind of dispute. Right now, we won't be able to do that. Information is not at hand.
No, it's not a problem. I can maybe call you after the show, or I can leave my details. If you can just transfer me back, I can leave my details.
They will attend to you. Thank you very much.
Inshallah. Jazakallah so much.
Okay. All right, Junaid, we were saying that community service is also a possible sentence, as is a fine. But it appears that the public doesn't always understand why sentence, they interpret sentence to mean only prison, correct?
Yes, correct.
Now, what you've said is there's been a huge development in the law from the time that we now have the new constitution, and the principles underpinning sentencing has changed.
Correct. So a court is not bound to the legislature in terms of the prescribed minimum sentence or maximum sentence. It can deter where there is substantial mitigated factors that are justified and taken into account by the judge, then or the magistrate, then he or she can deter from the prescribed minimum sentence.
Let's just pause on that point. Caller, please go ahead.
Assalamu alaikum.
Walaikum salam.
My name is Bashir.
Welcome, Bashir.
I follow the case of Oscar.
Yes.
And I don't understand that people don't understand how people that's got disability cannot be afraid. And there's a lot of people in our society that's taking people for disability to be normal. And I've just lost my eyesight now for the last 5 years, and I'm 45 years old.
Right.
In my own house, just a shadow puts fear in your body. So I don't understand how the court and our societies are doing this.
I'm not able to contribute. I won't be able to give an answer. Junaid, would you be?
Sure. Look, I think what you're trying to say, Brother Bashir, is that you've developed you've developed a sense of defense, a defense mechanism in you due to your eyesight being lost. And like you say, where you see a shadow, you are immediately instilled with fear. But that doesn't mean that you can just start going on a rampage and shooting wildly. I mean, you need to, you are still able to comprehend a right from wrong, and you would able to understand that by you pulling a trigger, there are consequences, and consequences have certain reactions which will come to your detriment if you can prove otherwise. But if you can comprehend that you can hurt someone by doing such an act, then I don't see how, that you must take precautions. Yes, I'm not saying that you shouldn't, but you should also be careful in what you do and how you do it.
Remember, the test for culpable...
I do understand what you're saying, but that spur of the moment reaction is like you just see something in front of you and your hands react. You're in that state of fear. Your mind is in another world. You understand? Mm-hmm. Immediately, you react. You see stuff in front of you that's not even there.
Right.
Yes.
Remember that the test that the court might use in that case is that of the reasonable man. So the reasonable man in the position of the accused, what would he have done? What did the accused do? And what did the accused fail to do? That is a different test. That is the law.
What steps rather did the accused take? And if he took certain steps, what steps did he take? Mm-hmm. This test has come from the case of Kruger versus Kutsia.
Right.
But what we were discussing earlier in the car is, Brother Bashir, when I defended somebody that was charged for culpable homicide, and as a result of the driver in front of him hitting dead brakes, he swerved onto the gravel road and could not control his vehicle. That then takes away the reasonable man's test, and I used the sudden emergency test as a defense. And that takes away the reasonable man factor, because with culpable homicide, which is negligent killing, all the state needs to prove is 1% of negligence. So to take away the reasonable man test, you can go with sudden emergency, but you've got to prove that you were in a sudden emergency. So you don't need to look out for what would happen to another. In a sudden emergency situation, it changes. You now need to do what you have to do to protect your life. Understand? And as a result, this is what happened. My client did what he had to do to protect his life. As a result, somebody died and he was charged with culpable homicide. But the state failed to prove their case beyond a reasonable doubt, and therefore I moved for a Section 174 discharge, and my client was thereafter released.
But I just want people to know, people with disability, right? They're normal people, but I'm just saying mindset and everything, speaking, everything is well. But the minute you get startled, your heartbeat rate is so high that you can get a heart attack. You understand?
Right.
That's how scared you become.
I think your contribution is well taken, Brother Bashir. I think we understand what you're saying is that people with disabilities, especially those without sight, have a heightened fear or have a heightened sense of fear and may react differently to people with full sight. Yes. I think that's your contribution.
Yes, okay. Jazakallah.
Thank you very much. Okay, we ask the viewers to please stay tuned. We're taking a short break and we'll meet you on the other side of the break. A few minutes more.
That's what I was telling you about in my car. It's a defensive mechanism you build in yourself.
So what else are we going to speak on sentencing?
Now we're going to talk about just aggravating circumstances.
Aggravating, right. So
you were wrong on previous conviction being mitigating. That's an aggravating circumstance.
Oh, is it?
Yeah, because that if you could be
IBO
declared
is
a
now
habitual
expanding by
criminal,
popular
that makes you a
demand.
danger to the public.
From
And then you
October,
need
our
to be
wide
punished
selection
in
of
the
famous
correct
brands
way.
will be available
what
in
we're saying
Springfield
is-
Park Value Centre, Durban. We'll be stocking everything from shirts, pants, and footwear at the best prices. Not only that, but we'll be giving away 1,000 pairs of shoes on our opening. So come to Springfield Park Value Centre, Durban for our grand opening. IBO, International Brands Outlet.
SA's leading bathroom design store, offering exclusive products and the world's leading brands in sanitary ware, taps, tiles, and bathroom fittings. Why settle for less when you can have the best? We offer value for every budget. Visit our exclusive showrooms to experience why we are different. Exclusive brands, customer service, variety, value, and backup support. Classic trading, luxury bathrooms.
Welcome to Dada's Motorland, South Africa's premier used exotic sports car dealership. We stock only the best from BMW, Mercedes-Benz, Porsche, Ferrari, Lamborghini, Aston Martin, Maserati, and much, much more. So if you have the need for speed, come into one of our branches and select the vehicle of your choice. With dedicated staff to ensure your satisfaction, there's no better place to get the wheels of your dreams. Dada's Motorland.
Throughout history, there have been many champions of flavor and taste, but Jimmy's still reigns supreme. Our Killer Grill's menu boasts the sauciest steaks, spicy and tender chicken dishes, beef burgers. We are leaders in explosive and flavorful taste experiences, resulting in amazing journeys of delight. Try us for our superior taste, adding excitement and zest to your life. New restaurants open countrywide. Jimmy's Killer Grills. The addictive taste.
Assalamu alaikum and welcome back to Legal Ease, the show that converts legal jargon into legal ease. And tonight we're discussing sentences in criminal trials. We've heard thus far how a criminal trial proceeds, who has the duty to begin, and what happens after a conviction. We've heard that sentencing is not cast in stone, and the element of discretion has somewhat been tempered by the recent amendments to the Act. Now, Junaid, when it comes to aggravation, what does aggravation mean in a sentence?
This is obviously going to be brought to the fore by the state, where they will present to the court aggravating factors, such as if the individual or the accused has any previous convictions, and that he be declared, or he has been declared, a habitual criminal and is a danger to society, and on that grounds they would ask for a harsh sentence to be imposed, so because this person, although given an opportunity the first time where the sentence was a little less harsher, it did not deter him from his life or her life of crime, and he continued committing crime. So therefore, where previous convictions are rather recent and not 10 years or 15 years ago, those previous convictions can be expunged in terms of the criminal Procedure Act, Act 51 of 1977. So if you're looking at a first-time offender, they would say that, for example, that this person is a violent man or violent woman, for that matter. They would call in somebody to say that the appropriate punishment would be to imprison this individual as he or she is a danger to the public. And then the court will take all this into recognition before passing a sentence. And the court will then have to take into consideration the mitigating factors and the aggravating factors and weigh them apart or together, rather, and then pass an appropriate sentence. Where a sentence induces a sense of shock, and the community, where it's either too excessive or too
lenient.
Yeah, that's the correct word. And it would induce a sense of shock. You'll find that either the state or the defense team would then seek leave to appeal from the trial court.
Okay. Before we proceed with appeal, we have another call on the line. Caller, please go ahead.
Assalamu alaikum.
Wa alaikum salam.
My name is Shiraz. I just wanted to find out something.
Yes, Shiraz. Yes, go ahead, Shiraz.
Okay. About 4 years ago, my son was murdered. He was 21 years at the time. And after 2 years, he was given, the guys that murdered him was given a 15-year sentence.
Right.
Everything was caught on CCTV footage. After 6 months, the guys that murdered him appealed the case, and it's now gone to the High Court. The High Court now, there were 2 dates set. The first date, when I went in, supposed to be in August, and then now when I went through on Tuesday this week, which was the 14th of October, according to the state advocate, she said the attorney did not, or the appellate, something did not hand in the documents in time. But this has been going on for quite a while because they're now playing for time. So I just want to find out what can I do about it.
Well, if the appellant hasn't put their application for leave to appeal on time, that would be grounds. Normally they have to bring the application after sentence has been passed. Either side, the state or the defense team, has 14 days. They can ask for condemnation, but there must be a reasonable explanation for the delay as to the late filing, as to why they have not filed the application for leave to appeal within the appropriate time limits, If it cannot be justified, condemnation will not be granted. And if there was a delay on the part of the appellants, then I don't see how condemnation can be granted. However, you find that sometimes if there is a good chance, after reading through what is stated on affidavit and presented in the application to the higher court or the appeal court, they might be lenient, and for the interest of justice, read through the records and listen to what the state and take this matter and listen. If it's before one judge, it will then go to 3 judges. They will then sit. It's called a full bench. If they can then ask or uphold the sentence and the conviction, or set it aside. But there are various different reasons when a sentence can be set aside or dropped. Instead of given 15 years, be dropped to 8 years.
I think your other question is, there appears to be in your mind a delay in the appeal attorneys filing their papers. Now, as Junaid pointed out earlier on, the National Prosecution Authority is your attorney in this matter. So you're entitled to go back to them and have a full consultation with the attorney dealing with this particular appeal and ask him or her what that next step would be. Now, the next step could be that they would then say that the appeal was not timeously handed in, there was no application for condonation, and then procedurally refuse the appeal. So if they haven't procedurally complied, they can't even get before the judges. So your relief would be to go back to the prosecutor that's dealing with this matter.
Instruct them to put in a notice of intention to oppose the application and to file an answering papers for and on your behalf, because the state of the prosecutor is the voice of the people. Now, if you're saying it's 2 years ago, then certainly the delay is quite substantial. It's in excess of the 14 days, way excess of the 14 days. So, read what the defense team has put in the application, what they are saying as to why they should be granted another opportunity to be heard.
I'll tell you what happened very shortly was when I got there on Tuesday morning, the attorney, that guy's attorney was sitting in court. So I walked into the court, and then the lady that was with him came up to me and said that, look, this case is going to be remanded, but she didn't give me a reason. So I waited for the state advocate to come in to have a word with her, and she said that something was handed in late or something to that effect. But there were 3 dates to the High Court. And then I said, okay, before I leave, I need to speak to the judge. So after making a bit of a noise there, they took me into the chambers, and I explained to the judge what was going on. So she told this attorney that he can't leave now. He's got to argue the case, and it's going to be remanded for next year, April or May, and there's going to be no more delays.
Okay, so there you've got directions already. That's extremely helpful. Normally, people don't get to see the judges in chambers. So there you have a very, very specific direction. The judge has said no more delays. Last day for the appeal will be in April 2015. The attorney has to prepare. But you must please go back to the prosecutor, to the advocate that's acting on behalf of the state, and liaise with him or her. Correct, Junaid?
That is correct. And read through their papers, and where you can give input, give your input. Because at the end of the day, two minds are better than one.
In fact, it's a very, very pertinent point that Junaid is making. What you need to do is understand the basis of the appeal. Usually it'll be factual, that the judge erred when it overlooked this, the judge said this, the judge said that. This is not something personal about the judge. It's the judge's view of the facts. Now, this is what the appellant is going to say to the appeal court judge, and you need to be able to counter that. And all of this is counted on having a proper copy of the record and properly understanding what the appellant's attorneys are saying. And you're entitled to be involved.
Okay.
And just one more thing before I let you go. When I said earlier that proper procedure needs to be followed, Ashraf, in the court and the judges and the magistrates are bound to the procedures. Where there are material irregularities and defects, where, for example, there was a case where the judge addresses the accused directly when he had a legal representative, that there is a material irregularity. That is something, if you have an attorney present, the judge cannot directly ask you questions. Your legal representative is your voice.
Unless the judge is asking clarifying questions or something at the end of the day that he's not happy with, the judge can address. But there you go, that's the guidance you need for this matter.
Hope it helps.
Okay?
But the problem also I experienced was like these attorneys, they speak to the state advocate, and the advocate, they discuss things with them, and then they come back and the state advocate, agrees with them. So sometimes it's a case of knowing one another, and, that's why I said they play for time. But when I made a noise, that's when the judge called me inside. in the courtroom, because there was quite a few people there, and I said, I'm not going to take this anymore.
What you can also do then, if you are unhappy with way the state advocate that is appointed to deal with this specific matter, you can always write to the Director of Public Prosecutions or the Deputy Director of Public Prosecutions with a complaint, lodging a complaint, and asking him or her to look into the matter basically, and to give you reasons as to what is actually happening and why the goalposts are now being shifted, should I say.
Look, I think you've been very proactive and extremely helpful to the case, and you've done very well. Just continue following it and go back. If you're unhappy, go back.
Yeah.
Okay?
Okay, Jazakallah.
Thank you.
Walaikum
salam. So, Junaid, we were talking about aggravating circumstances in sentencing, and you've tried to indicate what the judges would look for if there is a aggravation. Typically, what would they look for? You were saying that if there's a previous conviction, habitual criminal activity, it doesn't appear that your previous sentence worked. What else?
If your mitigating factors are not justified,
right,
that will, come to your detriment. If you present a false version to the court, you are asking for trouble.
Right.
And like I said, you must be able to justify it. If you cannot, it then becomes an aggravating factor against you, and you can be seen, last thing you want to be seen as a dishonest person in the eyes of the court.
So an aggravating factor would be previous convictions.
Yes.
I think just a few days ago there was a horrendous crash involving a truck driver, and now it appears that that truck driver has got previous convictions for reckless and negligent driving.
Yes.
So that would be a factor that they would take into account when they're assessing him in this new matter.
And now it's the same charge again. And what happens is that it starts off as a Schedule 1 offense, and if you do repeat that same offense, it then becomes a Schedule 5 offense, which is more serious, and you don't get released on bail. You cannot get prosecutor bail or after-hours bail. You need to have a formal bail application drawn up and presented before court.
Now you've touched on something extremely important. After-hours bail. I know we don't have a lot of time, and you've spoken about scheduled offences. Where does one find the schedule? Let's say I'm arrested for having skipped a traffic light.
It's a Schedule 3 offence.
Right.
It's not something serious. You still can get after-hours bail.
Right.
For rape of a minor, you will not get after-hours bail. Your after-hours bail normally falls where you can also get police bail is determined in the schedules of the Criminal Procedure Act 51 of 1977, and you've got to look at where a prosecutor can grant bail as well. You need to look at where it falls in Schedule 7. It's important that you liaise with the prosecutors, and if they are willing to assist you.
I think most people actually don't appreciate that you can get after-hours bail.
Yes.
You can.
Yes.
So it depends on the kind of crime that was
that is correct. Yes.
committed. Now, just with regard to the final word on sentencing. So there is a tension between aggravation and mitigation.
Yes.
At the end of the day, both sides would give their views.
Yes.
And the judge would make a finding. But once a sentence has been passed, you've indicated that if you're unhappy, you have 14 days to appeal.
That is correct.
And the process for appeal goes to the High Court.
Yes. From a magistrate's court, you go to a High Court. You will then sit before. If you're in the High Court and you're sitting before one judge, you will then appeal. If application for leave to appeal is granted, you will then be before a full bench. And if it's denied, your application for leave to appeal, you can then approach the Supreme Court of Appeal and present your reasons there as to why an appeal should be granted to you.
And two things can happen. The appeal judges could increase or decrease it.
Yes.
Well,
or
Junaid,
confirm.
It appears that we're running out of time again, and this has been a fascinating discussion on sentencing in the criminal
Thank you
law.
for having me on your show. I appreciate it, and I hope the viewers, watching, appreciate it and learned from this program. like you said, I can't say it better than you, making legal jargon easy to understand.
Yeah, converting legal jargon into legalese. That was another episode of Legalese. Thank you for joining us, and until next time, Assalamu alaikum wa rahmatullahi wa barakatuh.